Mr. Speaker, can I thank you for your ruling in respect of cause, which I think is important because this being rushed as it is, it's important that members have the time to get their head around it and ask the questions that need to be asked of the Minister. Sir, having heard Dennis O'Rourke's contribution, I actually agree with him about the description and purpose clause, and I would encourage the Minister, who I know is a very competent lawyer, to consider the amendment that I have proposed, which actually endorses Dennis O'Rourke's point, which is that rather than saying remove any doubt about the validity of speed limits, we just simply say it validates speed limits, because that's a proper description of what it does. And it avoids as Dennis O'Rourke said, the weasel words, and I think we should just call it what it is. It makes absolutely no doubt that it is validating it, so I would ask the Minister in the chair to consider that. It doesn't change the effect of clause 3A, it just validates it, validates the speed limits. Now, if there are some speed limits that don't need validating, well, we haven't done anything wrong, and if that was a valid complaint of the clause, that would be a valid complaint about removing any doubt about the validity of, because they are valid anyway. So I would encourage him to adopt that clause. The other question I have in respect of part 1 is a drafting clause around clause 5B, which says this bylaw does, in this Act, specified bylaw, and then B says does not include a bylaw that was made or purportedly made by a road controlling authority under any other Act. Now, given the way we use in A1A this Act, which is a reference to this bill, and then in 5A2 we list a series of acts, the Government Roading Powers Act 89 and the Local Government Act 74, the Local Government Act 2002, the Land Transport Act 1998 and the Speed Limit Rule 2003, I presume that we are saying that if B, when it says any other act, means any other act other than those listed in clause 5.2. I presume that's what it's intended to mean. I just want to check that that's the case. It might seem a silly question and it might be a silly question, but I just want that to be clarified. The other point, now that we, Mr. Chair, are talking about all parts at the same stage, I want to talk a little bit about clauses 8 and 9, because I think these are important reasons that make it easier for the Parliament to agree that we should be passing legislation of retrospective effect. Because as I read those sections, and the Minister can correct me if I've got this wrong, it effectively says if an enforcement action has been taken before the commencement of the Act, it's not to be treated as invalid because at the time then that enforcement action was taken, the bylaw may have been invalid. The making it retrospective effectively means that the enforcement action is validated as well. But then we say in clause 9 of the bill, which is an important exception to that general rule, is it doesn't limit any proceeding that expressly challenges the validity of the enforcement actions on the grounds that are specified in subclause 2 of clause 9 of this bill. So my understanding of that, Minister, is what we're effectively saying is if someone was already defending a traffic infringement notice or some other, could be a criminal charge for reckless driving or something, on the basis of the invalidity of the speed restriction that they had already noticed, then that defence can stand. So that we are not retrospectively imposing sanction in respect of offences or infringements that where the accused person has picked up that there is an invalidity and is standing on their rights to say no, this is invalid, I'm not guilty. We're not changing that person's circumstance, but if it hasn't previously been picked up, we're not letting them take advantage of the technical invalidity of the speeding notice. If I could have confirmation on those matters, please.